call page 4. This is case number 822-859-490C. This is Robertson versus Gorden. Marjorie Hauf of the Plaintiffs. Good morning.
Good morning, Your Honor. Sean Payne, also on behalf of the Plaintiffs.
Good morning.
Good morning, Your Honor. Loren Young for my defense.
Good morning.
Good morning, State Representative number 15955 for defendants Kody Gorden and Tigers baseball.
All right, good morning. All right, on blue jeans.
Good morning, Your Honor.
Go ahead, Gene.
Good morning, Your Honor. Gene Backus, appearing on behalf of ADJ Baseball, LLC.
Good morning.
Louis Gazda on behalf of Michael Stiles.
Good morning.
Good morning.
Jonathan Hansen on behalf of Michael Stiles.
Good morning, Your Honor.
Hansen,
Matthew Friedman on behalf of Fraser, Inouye. Sorry, Your Honor.
No, good morning, Mr. Friedman. Mr. Hansen, is this your first appearance? Have I just missed you in this case?
This is my first appearance. I've been here, but I've been stuck on other things, so I had co-counsel appear for me. So yes, I apologize for that, but yeah, I am on the case too.
Okay, no problem. No problem. I thought I was just getting to know all the lawyers in this case, and then I saw you appear. Okay, so let's start with, this was largely, I'm going to turn to Mr. Backus because he largely suggested the ESI protocol we moved under this during this very first phase of discovery. Mr. Backus, have the exchanges of information concerning devices and emails and social media accounts been made?
Essentially, Your Honor, the parties have disclosed in an abbreviated format the email accounts, the social media accounts that they utilized at the relevant time periods in this case. It is pretty abbreviated. There's no indication of what steps anybody's taken to preserve ESI. But the databases have been set forth in supplemental disclosures.
Okay. What I'm going to ask everybody to do is to, you don't have to file them, but I would like everyone to submit copies of their disclosures to me. You can send those by email. It's at .us. And that will simply help me as we meet periodically together to understand what I'm working with. Mr. Backus, I think the other item that I ordered based on your request was supplementation of the description of the disclosed witnesses' subject matter knowledge. Has that been done?
I have not totally reviewed that. I know I did that in great detail. Some parties have done it in fair detail. I can't represent to Your Honor, though, that everyone has done it in their 16.1 disclosures to fully set forth what information each individual disclosed may have.
Okay. Let me shift over to plaintiff's counsel now and ask, have the witness disclosures been done?
Yes,
Supplementation.
Yes, Your Honor.
Okay, very good. And let me go to other defense counsel in the courtroom. Have you made your witness supplementations of subject matter disclosures?
For Michael Stiles, yes, we did.
Okay.
As far as I'm aware, we have.
Okay. All right, based on that answer, what I'll say is, please double check, and if you haven't, please make sure you do so immediately. All right, let me go online to Mr. Gazda, Mr. Hansen, and Mr. Friedman.
Yes, Your Honor. Our production was with Mr. Young and Mr. Hansen. We all represent Michael Stiles.
Okay. All right, and Mr. Friedman, have you done your?
We have, Your Honor. We have,
okay.
and to the extent that anybody requires additional information relative to this disclosure, I'm happy to supplement. But we have updated them with greater specificity, I think, than what we prototypically see. So I haven't heard that anybody has any objection with the way that we've disclosed them.
Okay, if anybody has any objections or requires further supplementation, I will have in front of me the disclosures the next time we meet, and so I can take a look at those disclosures and assess their sufficiency the next time, and you all can raise that. My next question is, I can't remember if I just did this in my head or if I actually ordered you all to do it, but did I order you all to also produce all electronic communications with one another, meaning by and amongst the parties here?
My knowledge, you did not yet, Judge. Not
all right.
that you might not, but you did not at the last hearing.
Okay.
Just identify it.
Okay, just identify them. Okay, so that was just that was just something I was muddling in my head. Okay, let me go to plaintiff's counsel now, and this is your opportunity to raise any preliminary discovery issues as well as provide input on what you think the next phase of discovery should be, given that we've completed this preliminary phase. Ms. Hauf, I'll start with you and then I'll move on.
Thank you. I think the next thing we would need is subpoena power to try to get some of these records. I mean, obviously we can take control of our clients' own devices. We can send them off to an ESI specialist who can get off what they can get off of the devices. But as we disclosed in our disclosure, one of those devices was wiped clean to give to a child before this lawsuit was filed. So we're having some difficulty with that. We don't know if it's going to be, I mean, when I update my phone, I don't know anything about this stuff, but I know when I update my phone, I give it to my IT guy, and all the stuff on my old phone is now on my new phone, and
Right.
And we haven't had the opportunity to examine the new phone, to get the new phone off to the expert because he's in Washington. And
When you say, let me back you up just for a second. When you say subpoena power, what are you thinking of subpoenaing?
well, because I'm afraid things are gone from, like, for example, the apps or
Let's back up
The-
again. I think you're still 2 steps ahead of me.
maybe.
Listen, what person or entity would you like to subpoena?
I think I don't know.
Okay.
I don't have an answer for you, a good answer for you at this time
Okay.
about that. I think we would need to put together that in some detail after consulting with an expert, seeing what we already have.
Okay, so what I'm hearing from you, and correct me if I'm wrong, is that your client has certain devices, I don't know which they are yet because I don't have the disclosures in front of me, for at least one of the devices, which I'm guessing is an iPhone based on what you said, it was wiped clean. You don't have a full appreciation, which I understand and appreciate, of exactly what a wiping clean does to a phone. And so on one hand, you need to get that device and perhaps others of your clients' devices to an expert to extract the electronic information from those devices. Depending on what you may or may not extract and what your extraction technician is able to do, you may need subpoena power over a third party such as Apple or such as Google or these third-party companies that actually that may store some of the information that was otherwise wiped from the phone. Is that accurate?
That is much more articulate than I had said, but yes, that's exactly what I'm saying.
No problem at all. Okay, all right, I understand. All right, can you tell me your name again? I'm sorry.
It's okay, Your Honor, Sean Payne, also for the
Payne.
elections. Payne.
Okay, Payne. Okay, and you represent the plaintiffs in their capacity as counter-defendants, correct?
That's correct, Your Honor.
Okay.
And Rebecca, Mr. Angelo from my office, is handling most of the day-to-day of this case. She intended to be here. She had to leave town this morning for an urgent family matter
Okay.
across the country. She did encourage me to advise the court that, she has had communications with counsel for all of the parties. We understand that preliminarily in this case, we need to identify all of the documents and have everybody disclose them. The parties are aware of these communications that took place, whether or not they have been deleted or not. I mean, there's some understanding from the parties, and there's a desire for some form of early ADR, like whether the court orders us to a mediation or a settlement conference, after some of the disclosures have been made, and maybe if the parties are insistent, some limited written discovery as well, because immediately after that, we're going to get into depositions. It's going to be dozens of depositions and great cost to all the parties as well.
So let me tell you about mediation and ADR. If everyone agrees to go, I have no problem, I'll use air quotes, ordering you to go, because at that point, it's not really an order, everybody's agreeing and you're going of your own accord. The reason I say that is because we have a court settlement program here. However, if one party, and I can send you to the court settlement program. However, if one party objects, you get kicked out of the settlement program. So it's a bit illusory in a way. And so it really does take the agreement of all the parties in order for you to participate either in the court settlement program or private mediation. So I'm happy to make that order, but I always tell everybody, my order is only as good as your desire to follow it.
Sure, and it was our understanding based on communications with counsel for everyone that's present here today, for all the parties, that there was an agreement. I think maybe the issue was more of timing and whether or not we are, at what point we're doing it in this discovery process. Obviously, there's some degree of staggered discovery happening here, and we're trying to understand all of the information that we need to obtain, which devices they're on, and so forth, and that's progressing already. Before we get to that next stage of just starting to set depositions, I think that everyone would benefit from attending some sort of settlement conference or mediation.
Yeah, and it might be the first of several settlement conferences. You may not settle at the first settlement conference. You may have to get in there and figure out what everyone's positions are at the first settlement conference. You may have to go to a second settlement conference after you do a little bit more discovery.
That's fair, yes.
Yeah, I understand. All right, let me turn to Mr. Young.
Thanks, Judge. At least for the next stage, I guess is the question. I think similar to what you and Ms. Hauf was talking about, the ESI, I think, is the first stage that everyone should be doing, is getting their devices to experts to extract the data and then produce it. And then I would like to propound some written discovery before going any further. I think that would focus my client and in our case, whether it be on the defense or the counterclaim, as well as focusing, what is specifically about my client. That's what I would like to do for written discovery. And then at that point, I think we can then consider whether we all want to go to an ADR or settlement conference. I think those two things need to get done first, and then we can consider that part. And I agree, that needs to be done before that.
Okay, all right. And tell me your name again?
Kate Ludwick. Yeah.
Ludwick, okay.
And well, after discussing with Mr. Haight, I do know that we had Mr. Gordon's phone image at the beginning of this case with Holo, but of course that's only going to show what was on the phone at the time. So
Did the imaging extract not just what's on the hard drive of the phone, but also did it go into the accounts? Like, for instance, I have a Gmail account on my phone, and
I don't know the answer to that.
Okay.
I know we have an affidavit from Holo, so I don't know for sure whether that information can be recovered from whether Apple or Meta or whatever the other apps that they were using, but at this point, I do know we did have his phone imaged.
Okay.
It just briefly, it's been my experience that when you're talking about these types of accounts, a Gmail, a Twitter, that type of a situation, that the data that Your Honor is referring to is often stored on their servers, not on the devices itself. There may be some backing up that goes on there, but that, when we engaged an expert for this purpose, and I've done it a number of times, but even for this one, in discussing the various accounts, different places they're going to look, right? The phone's going to have one sort of data. It's going to have files and things saved to the phone. The, social media accounts and email accounts, prototypically, all of that data is going to be, at least, going back a ways, is going to be cloud-based in its origin, I guess I would suppose, Joe.
I think you're correct, Mr. Friedman, on the one hand. On the other hand, I think Holo, because I've actually used Holo to do this, they can extract the data that's in the email account so long as they don't have to go through a password, basically. So they can take your phone.
Totally agree, and that's who
Right,
I'm using
yeah.
for this as well. It's just not in the phone itself, is what my understanding.
Right. No. We totally, I think we're in agreement there. It's not necessarily on the phone's hard drive, right? It's on the hard drive of the cloud-based server. Whether you can extract it is a separate question. Okay, since Mr. Friedman, since you're talking, what's your input? What do you think the next phase should be?
I would agree with Mr. Young, and I think we had productive conversations to this end, which were simply, okay, if we get the ESI protocol locked in, we can do some targeted written discovery. And then that's, I think, at least with respect to some of the co-defendants, my clients certainly, that's going to narrow the focus. I think Mr. Young shares this position, as well as Mr. Gazda, with respect to Mr. Stiles. I think that for us is kind of what we'd like to see happen before we kind of move on to another phase here, Judge.
Okay, and can we ask Mr. Hanson, Mr. Gazda?
Yeah, no, I agree 100% with Mr. Young's position on this. I do think that if we're going to be trying to obtain information from entities such as Instagram or other things along those lines, that we are going to need some sort of authorization. Subpoena power is not going to be enough. So I think we'll need to create some sort of an authorization so we can actually obtain this information.
I
would assume the best we're going to get is probably an order from this court, an express and specifically tailored order. And even with that, I think we're going to have our work cut out for us.
Yeah. They frequently just ignore it.
I think it will work like medical records and HIPAA largely works with hospitals, which is if the patient, here the owner of the account, if they authorize you, Instagram, Meta, well, Instagram is Meta, they don't have a problem turning it over at that point, right? Alternatively, just like with HIPAA, right, I can order that the information be produced, and I can order that that the entities such as Meta, as long as they're within my jurisdictional powers, produce the information, even if the owner of the account hasn't provided an authorization to obtain the information. So that's largely been my experience, but large companies surprise me all the time with their resistance to turn over information, so I'm sure I will be surprised at some point in this case. Mr. Backus, what's your input? What do you think the next phase should be?
Thank you, Your Honor. I have a couple of ideas, and I think some of the parties have already paid lip service to at least some of this. It would be good to have the parties identify what steps they have taken to preserve ESI that may be relevant to the issues in this case. We've already talked about identifying the software applications, the computer programs, and databases used in conjunction with Brittany Robertson. We probably need, if it has not been done, to disclose the full names and role and title of any key custodian of any potentially relevant or responsive ESI. I think your prior order probably did cover the identification of all email systems, and I think the parties have tried to set forth their email accounts. As far as, I think one thing that would be good is for the parties to identify, as one of the counsel did this morning, identify any special issues or impediments they anticipate in timely disclosing responsive ESI.
All right, this is what I'm going to do. Go ahead.
No, and then I would agree that written discovery following the disclosure of the ESI would be appropriate.
Okay, so this is what I'd like to do. I'd like to see you all again in 3 weeks, the week of September 18th. At that point, to the extent any, okay, let me back up a little bit actually. Let's do this orderly. I would like your disclosures If anybody's disclosed documents, you do not need to give me the documents that you've disclosed. What I want is, I want your identification of witnesses. I want your, to the extent you've identified, my Bates number, any documents you've disclosed, that's fine. And I want your disclosure of the devices, the social media accounts, and the emails with relevant information. And I'd like for you, as I mentioned early on in this, I'd like for those emailed to me, and I would like those emailed to me by next Thursday, September 7th. I'm going to do an in-chamber status check on September 8th to ensure that I have a disclosure submitted to me from each party in this case. And then over the course of the next couple of weeks, by the 14th, I would like for everybody to set forth in your own status report, which you can file, what steps you've taken to preserve the ESI that's in your client's custody, possession, or control, including, for instance, if you've imaged a device, then I'd like for you to say that you've imaged a device. I'd like for you to identify what that image entails, okay? You don't have to get down to the nitty and gritty of every document that might have been imaged, but for instance, I would like to know, did you just image what's on the hard drive on the phone? Or did the imaging also happen to grab certain email accounts or certain social media accounts that was on the phone? And I understand you may have to go to your litigation support specialist, such as Polo or whoever you used, in order to get that information. So I would like that filed by the 14th. And I'll do an in-chamber status check on the 15th for the filing of that status report from every party. Also, if you anticipate, like Ms. Hauf said, issues with the preservation of ESI, I would like that identified in the status report as well. Like, for instance, if you know that certain ESI has not been preserved because 2 years ago, before anyone anticipated this lawsuit coming to light, and I'm just making up numbers that may not even make sense, or time periods that may not even make sense, you wipe the phone, right? Or you wipe the phone and you donated it to someone. I would like those identified in the status report as well. So any special issues or impediments to ESI. And then what I'd also like by the 14th is I would like for you all to have served on one another your first round of written requests for production. Please be judicious in what you request. Please do not send one another 100 requests for production, okay? That's facially burdensome. And the reason I want you all to have done that by the 14th is because when we get together again on the week of the 18th, I would also like, we typically don't file discovery into the record, but I would like for you all to go ahead and file that along with your status report. Because I'd like to talk about it, and I'd like to talk about any preliminary issues with the requests for production when we get together the week of the 20th. And so that's why I'm asking you to have served it and also to file the status report. And we'll do an in-chamber status check on the 15th as well to ensure that the requests for, the first round of requests for production are attached to the status report. And what I'm really anticipating, counsel, is that for that first request for production is going to be seeking items that would be in the preserved or the to be preserved ESI here. And it's really a top line kind of request for production where you're getting the basics of what you need to assess your claims in this case so we can move forward to the proposed mediation at some point, okay? All right, have I failed to cover anything that council need to address with me? Mr. Young, I see you standing up.
Judge, I remember Mr. Backus submitted a proposed order regarding ESI. Did you happen to have a chance to look at that?
So I think Mr. Backus, thank you for reminding me of that. Mr. Backus submitted two things, I think. He submitted by email, which I think everyone else was CC'd on, the ESI master protocols that Judge Gonzalez used in the city center case, which I haven't fully digested, and I'm not, I have looked at them, but I haven't fully digested, and I'm not prepared yet to enter into this case, mostly because I'm not at the point where I'm gonna appoint an ESI master in this case. Mr. Backus, I think you said you also submitted a proposed protocol for this particular case that was defined to this particular case. I could not locate it. Would you ask your office to please submit it to directly to my email address?
I will do so, Your Honor. Actually, there were two versions of an ESI order. At the early case conference, we had proposed an ESI order to be stipulated between the parties. So we had that format, and I can provide that to the court as well.
Thank you, and that's going to be helpful only because, and everybody else can weigh in on it, that's only going to be helpful because once I know the universe of ESI we're dealing with, how much data we're dealing with, and what types of requests you all are seeking, or what types of documents you all are seeking from one another, we're probably going to have to discuss, well, what search terms are we going to use for this, right? Because if we're dealing with a lot of data, for instance, if we're dealing with 50,000 emails, it may not be fair to ask someone to, read 50,000 emails to find a handful of documents. And same thing with text messages. Text messages in particular are incredibly burdensome to go through. I know with my own text messages, just trying to find a text from
Can I raise one thing briefly,
a couple
Judge?
days ago is difficult.
Can I raise one thing briefly that you just kind of mentioned in a touch, and this may be defined in the protocol that Mr. Backus is referring to, but my understanding is not all preservation is created equal. So you can have somebody forensically image a phone or a hard drive from a computer. It doesn't make it workable in the way that Your Honor just cited to, which is being able to search it and do key search terms when you have voluminous documents. I think it would probably make sense to at least have some basic standard across the board so that we know that, for example, if we want to agree on queries and search terms, that everybody has done an appropriate level. It's not just a dump of data onto a hard drive that's preserved, but it's actually been, put into a format that's searchable and can be, easily accessed. Certainly it's what we're going to do. I'm assuming a lot of the counsel on here are going to do the same, but I think it's just important that there is some standard so we're not back in front of Your Honor at some point in the future going, oh, well, gosh, our expert didn't do that. We don't have the capacity to search it, so we'll just turn everything over, that type of a thing.
So a couple of things in there, Mr. Friedman. I'm not prepared to do that yet because I don't know the quantity of data that I'm dealing with. So for instance, if somebody has a very small quantity of data, it may not make sense for them to go to the expense of what you're basically talking about is putting the data into a repository that can be searched, right? Like a document review repository. And that there's always an initial cost with that, and then there's ongoing costs with that. So if somebody doesn't have very much data, I don't know if it would be proportional for me to order them to necessarily go to that expense. So I want to do this step by step where we figure out how much data are we talking about for each person. Okay.
And that is, there are some of those provisions provided in that order by Mr. Backus that kind of helps us figure that out, what Mr. Payne was talking about. So,
Okay.
yeah, it's in there.
All right, very good. So I'd like to meet preferably the week of September 18th, but if council's schedule doesn't allow, then the week of the 25th. I'm going to put you all on a special setting. It'll probably take a little bit of time. So I can see you all on almost any day either of those weeks? Is there any day, and let me start with plaintiff's counsel, is there any day that is bad for you? And remember, this is a special setting, so we'll go outside of motion hour.
Looks like the 19th would be particularly good for me.
Okay. So let me ask everybody, since the 19th's been thrown out, would 10:30 on the 19th work for you, or would sometime in the afternoon work for council if you'd like to get past regular motion hour?
10:30 would be fine on the 19th.
Okay, Mr. Young?
On the 19th, the only thing I have is a settlement conference at 1.
Okay,
So if we're done before then, I'll be here already.
I hope we're done before 1
Yeah,
o'clock.
me too.
Ludwick?
Yeah, 10:30 on the 19th, we have another status check at 9 AM, but yeah, 10:30 would be good.
All right, let me go on. Mr. Backus, would 10:30 on the 19th work for you?
That's excellent, Your Honor.
Okay. Mr. Friedman, would 10:30 on the 19th work for you?
I'm actually in trial, Judge, but I certainly can have somebody covered. If I'm going to be the only one that's the fly in the ointment, there's an attorney from my office can be present.
Okay, let me ask Mr. Gazda, Mr. Hanson, would 10:30 on the 19th work for you all?
Yes, Your Honor.
Okay, very good. Then we'll do a special study on 10:30 on the 19th. Okay,
Sounds
and
good.
it'll just be you all, so we'll have plenty of time to talk.
Thank you, Ron.
Okay,
Thank you, Your Honor.
thank you so much. Have a good day.
Thank you, Your Honor.